Yes, Mr. Ghosh.
I'm grateful, my Lord. May it please the Court, I appear with Mr. Welsh and Mr. Hoyle for the appellant. My learned friends, Mr. Thompson and Mr. Anderson, appear for the Respondent Commissioners. I wonder, please, if I might do this. There are two issues before the Court. Both of them are short points. Both of them have critical, fundamental words of that nature importance about the compliance and enforcement powers of HMRC. In the written case, issue number 1 is to do with the scope and archaeology of Section 73 of the VAT Act, and issue number 2, that's to do with whether HMRC have an implied power when there's a claim made for the repayment of excess input tax to deal with that claim in a way that's outside the express words of the statute, but they've got an implied power. With the Court's permission, can I deal with that issue first? That was a question rather than a statement, but if the Court is content with that, can I do that?
Whatever is convenient to you, Mr. Ghosh.
I'm very grateful. Issue 2 is this. DCM say we have an excess of input tax over output tax. We would like, please, to have that excess paid to us. And I'll show you, I'll take my submissions short, make them, and then I'll show the Court, with the Court's permission, the relevant passages in the authorities, the relevant statutory provisions, and how it was that the first-year tribunal in particular dealt with this. Now, what HMRC did was to issue what these were decisions, but these were decisions, importantly, which are not assessments. They're not a direction to the taxpayer to amend the taxpayer's return. That's common ground. It's neither of those. But rather, it was a decision which HMRC, what they say, has the effect of suspending the taxpayer's VAT account. And what does that mean? It means that the time limits for issuing assessments, anything of that nature, were suspended until HMRC had satisfied themselves that the claim was good. Now, the reason it's important, and I will most certainly be taking the Court to what it is that the revenue say their power is and what it is that the revenue say that the effect of this exercise of power actually was. Now, the reason it's important that these aren't assessments is because if they had been, they were out of time. If they had been Regulation 35 directions to amend the taxpayer's returns, if there'd been one of those, they would have been out of time. But what the revenue say is that they've got an implied power to investigate and take a decision that are not subject to the time limits to do with assessments or Regulation 35 amendments. And that any limitation on that power comes from public law and public law alone. And we say that they don't have that power. And to trail what this issue is to do with, they say they get this power by implication from one or both of care and management powers, Schedule 11, Paragraph 1, or Section 25 of the VAT Act. Now, on the face of the statute, when a claim for colloquially repayment, but a payment of excess input tax is made, These are the powers, if I may, I'll give the court a list. These are the powers that on the face of the statute HMRC has got. 1, HMRC pays it subject to conditions, so that's any conditions, including repayment. And for your note, that's section 25(6). I'll show you this. 2, they can pay, and then if they've decided that they shouldn't have paid, they can assess for the money back. 3, they can not pay until they've been given supporting evidence. That's Schedule 11, paragraph 4. 4, they can pay but ask for security. That's, again, it's Schedule 11, paragraph 4. Just for your note, the version of Schedule 11, paragraph 4 in the bundle is a 2003 version. The pre-2003 version is not so different. 5, they can ask the trader to amend their VAT return under Regulation 35 of the 1995 regulations. So there are 5 courses of action HMRC can take expressly on the face of the statute. 2 final points just on this. Section 25(3) says in terms, the default position is that the commissioners on being met with a claim for payment of excess input tax shall pay that. So it's mandatory. That's the default position. And there is an express right to withhold, simply not pay. This is in section 25(5), if the trader has not made VAT returns.
I'm sorry, I didn't hear that sentence.
My Lord, there is an express right for the revenue not to pay if the trader has not made VAT returns. That's section 25 sub 5. I will show you this. Now, DCM had made VAT returns. So we say what the revenue should have done is used one or other of these other powers I've mentioned, but they didn't do that. They did something else. HMR did something else, something other. What was that other? They made a series of decisions, and I'll give you these when I get to showing you the FTT decision, which were described as protective assessments, but I've said now already they're not assessments. And what these purported to do was to make amendments, not tell the trader to make amendments to the VAT return. They purported to make amendments. But actually what HMRC say these do is, I called it a suspense, they call it an inhibit. They put any right to an input credit or a payment of excess input tax on hold. And this is something you could not have told on the face of these communications. They say what these communications do is they make you, the trader, wait until we have decided whether or not your claim to a payment of input, excess input tax is good. And that also has the effect, I've said it now more than once, of suspending what otherwise are time limits, prescription periods, limitation periods in Section 73 assessments. And we get to do this, because we have an implied power to make this inhibit. And these are the features of this implied power. 1, HMRC can decide not to repay or not to pay until they've established the correctness of the claim. Now, pausing there, that in itself is problematic, but what does correctness mean? It must mean correctness in their opinion. 2, you have no right, you the trader, to an input credit until we have established the correctness of this claim. Again, bracket, that must mean in the opinion of HMRC, close bracket. And this is problematic because if the whole essence is that there is a dispute, a legal dispute, as to whether there's an input credit or not, that needs to be fought out before the tribunals and the court. The second feature, that there's no right to a credit until it's established or adjudicated, words of that nature, simply is a synonym for it's in the opinion of HMRC that it's established. The third feature of this implied power is that time limits on assessments, Regulation 35, directions, they're suspended until the establishment, in HMRC's opinion, of this right to a payment of input tax. Four, the burden is on the trader to displace this decision. And 5, there's no need to communicate the nature of the decision to the trader, because, as I keep saying, what I'm about to show you is that none of this was apparent on the face of these communications that were described as protective assessments. And they say, what HMRC say about this is that it's a necessary implication that this power exists because Schedule 11, Paragraph 1, Care and Management, together with Section 25 of the VAT Act, necessarily implies the existence of this power. And we say that's just wrong. If I might please show you these decisions. The FTT decision, it's the best place to find this. It's in the core bundle, divider 6, and it ought to be page 192 of the electronic bundle. Now, if the court please looks at paragraph 34, that's the overview of the issues. Little c originally described this issue as a quasi-assessment issue. That's how it was originally described by HMRC and the FTT. then you'll see the summary of these communications. That's at paragraphs 43 through to 53. And what you've got are a series of claims. These are appeals 2 right through to appeals 6 for VAT periods. And in each case, you've got this communication, this protective assessments in response. So, for instance, on appeal number 2, at paragraphs 42 43 and 44, you've got a claim for, and then you've got the communication on the 30th of July, 08. But that was for the period July 05, so 3 years after. And they're all like that. They're all 3 years after the claim was, after the end of the VAT period. And appeal, if you look under appeal number 6, there's a letter dated 3rd June 2013. It's at paragraph 53. And what that does is confirm the decisions made for appeals 2 right through to appeal 5 for those periods, and makes an additional set of decisions for the VAT periods October 06 through to December 08. Now, what are these decisions? That's what we find. It's on paragraph 118 of the FTT's decision, page 203. Now, 118 through to 126 tells us what HMRC thought these, what they were originally called protective assessments, what they were. In 118, you've got Officer Boyle giving evidence that what she thought she was doing was making a protective assessment. But that's not what it really was at all. That's not what the revenue thought it was. And that's recorded by the FTT at 119. Because at 119, you've got an example of one of these communications. And for your note, just in case the court wants to, these communications can be found Appeal 2 at page 566 of the electronic bundle. For Appeal 3, it's 570. For Appeal 4, it's 573. For Appeal 5, it's 574. And for Appeal 6, it's 576. But the court will see at 119 of the FTT's decision what this is purporting to do, and it's purporting to amend the taxpayer's VAT return. And there's reasoning given. If you look at line 20, it starts as per my letter of 15th January 2009, a protective assessment is necessary until a resolution is reached regarding discounts. The dispute was all to do with, well, do you or don't you get this payment of excess input tax? Because we think the way that it's been calculated is wrong, because the input tax is attributable to the wrong sort of supplies. It almost doesn't matter what the detail was. The fact is, the revenue thinks the input tax isn't payable, isn't repayable, and they're setting out this protective assessment. But it's not an assessment. I mean, that's common ground, but you can see why at paragraph 120 and 121. It's not an assessment because it was sent, this communication, because the revenue was still trying to find out what the right answer was. So there isn't a planet on which this was an assessment.
Would that give you a right of appeal under Section 83?
Yes, my lord.
It would, yeah. So you could have appealed as soon as you received that letter?
I suppose so, and a bolder answer would be yes. But there is a complexity here, because the revenue's position is that there isn't a right to a payment of input credit, and there is no right to a credit in your VAT computation at all. So your appeal would have been against a decision. That would be the relevant paragraph in Section 83, a decision to do with input tax.
But I mean, surely if you win the appeal, don't you get a credit then in your VAT ledger?
Well, so long as you know what it is that you're appealing against, because actually one of the problems here is, and I'll give you the references. This suspension was seemingly given not because of a dispute about over-claimed input tax, but rather under-declared output tax, which reduced your claim to how much input tax you could get back. And you'll find that, just for your note, paragraph 8 of the FTT decision at page 188, 48 of the FTT decision at 194, 64 of the FTT decision.
Sorry.
I'm sorry.
The paragraph numbers are, sorry?
8 of the FTT decision, 48, and 64. That's also what the upper tribunal thought at paragraph 1 of its decision at page 161, and at 17 of its decision at page 165. The division, the inner house, assumed the opposite. You'll find that at paragraph 36 and at 43 to 44 of its decision. Now, the reason this is relevant is because if you get one of these, and the court can see it, it says VAT is on sales is increased, VAT reclaimed is increased, net VAT is reduced.
What are you looking at?
I'm looking at, my lord, paragraph 119. This is this protective assessment. This is the decision that we're complaining about.
119. Thank you.
Oh, yes. Inevitably, the paragraph numbering that I am giving the court is from the FTT decision that I've got in my bundle. This decision was revised, and there are different paragraph numbers. I've got nowhere to go on that. This is all I've got, and I'm sorry.
Why is it all you've got? The numbers were. Is everyone going to be working from the bundle number for the purpose of paragraphs, or are we going to get into some confusion by working from the unrevised judgment and then the revised judgment? I just find out from HMRC what they're going to be working from.
Lord, my understanding is that both parties' written cases correctly identify the paragraph numbers in the revised decision.
Yes.
It's the revised decision paragraph numbers.
Well, so as long as it's made clear which you're working from, presumably in any judgment which this court has to write, we will have to work from the revised judgment, because that is now the authoritative judgment on this.
Is that the one we have in Simon's report?
That's correct, Lord, yes.
Yes.
Thank you.
I'm very sorry, and I apologise to the court and to my learned friend. if the court bears with me that with the paragraph numbers I'm giving the court, I will make sure in the course of my submissions, if there's a different paragraph number which I can give you sensibly, I'll give you that.
Thank you.
I'm so sorry. Which is the revised one? Is it the longer one or the shorter one?
The longer one.
The longer one.
Yes.
Okay.
Yes, it's the Salmons Tax Cases report that was submitted later on.
Malena Jr. wants to give it to me now. I think I don't want it now. I will refer to the paragraphs. It should be obvious which paragraphs I'm referring to. And I've said it. I'm very sorry that we have this, and I apologise both to the court and to my learned friend. Anyway, coming back to the question posed by my Lord Stephen, this is a decision, and it is appealable against, and actually we have appealed. That's the basis of our appeal. Our point is the revenue had no various to make them.
I'm sorry, I just missed that last bit. The point is?
The point of the appeal is that the revenue had no various to make these.
All right.
And you could appeal regardless as whether it was input tax or output tax. Is that right?
That would be right. Because it would be an appeal against the ultimate quantum of input tax that the revenue are saying that we're getting back is less than what we'd asked for. So that's right.
So why aren't your rights fully protected by appealing against this decision, as you call it? I mean, you're given very precise corrections to particular boxes in the VAT return. I mean, why can't you say, well, those figures are wrong?
Because if the revenue had this implied, we say, first, our immediate response is, we shouldn't have to, because if the revenue's got no power to make these communications and amend our VAT return and our rights to input tax this way, simply because we've got a right of appeal against it, isn't any sort of answer. That's point one. If there's no various to do this, then they should have no legal effect. And what's more, if they did have various to do this, it has what I've described, and I'm not over-egging this, a profound effect on the limitation periods, the prescription periods, the time limits in other provisions, including Section 76.
I'm sorry to come back to the same question again. If there was no alteration of input tax and there was only an alteration of output tax, would you have a right of appeal?
On the basis that the alteration of output tax reduced our net claim to input tax, yes, we would. Yeah. If they had used this power, this implied power, to say, well, actually, your net output tax is greater. So it's not just a question of you get back less input tax, you actually owe us money now. If that's how they'd use this power, if it was, and it's not an assessment, then it's far less clear what her appeal right would be.
You know, it's not simply the numbering of the two versions which are different. The text of the decision is quite different. Once you get the earlier parts of the decision look at first sight to be much the same, but the section you just took us to, including paragraphs 119 and 120, are
142, I think it is.
I'm sorry?
I think it comes. 119, 120 is now 190 is now 142.
Yeah. Yes, it's because there's quite a lot of extra stuff in the
extra material gone
yes,
into the
yes, yes. So it's actually a different. The decision has a different text.
And insofar as this makes any difference, and I'm ashamed that I'm having to read from this text, and I'm very sorry, I will deal with it in reply. It shouldn't affect my submissions. But the only point I want to draw to the attention of the court here is that it calls itself a protective assessment. It's not one of those. I've pretty much done that point now. It's not a Regulation 35 amendment. It's not one of those. Yes, we've got a right of appeal, and we've exercised it. But we're exercising it on the basis that they shouldn't have done this. And if they do have this power, it has, which I'll show the court, an effect on time limits on other compliance provisions, particularly Section 73, that Parliament could not have intended.
Well, what's the answer to the question, the proposition that the time limit is what's reasonable in the circumstances, the particular facts of the case, and you have an ability to apply for judicial review if they're not getting on with it?
The answer, my lord, is that where statute provides for specific time limits and statute provides for specific powers to HMRC in dealing with the claim for payment of excess input tax, those are the powers that should be used and they should be stuck to. And, my lord, just to be clear, you can see, and I am now frightened to mention a paragraph number, but just underneath the extract from that communication, you will see that it calls itself a protective assessment. And that word carries baggage because an assessment is subject to time limits. There are provisions which I'll be showing the court when I get on to issue the other issue. It's not one of those. It's not what it's purporting to be. So it's not a satisfactory answer to say, well, whatever it is, there are public law protections that will protect me somehow on a JR. The question is, does the revenue have this right to put an inhibit while they investigate a claim?
You accept, as I understand it, there is a power to verify and to suspend repayment until figures have been verified.
But yes, my lord, but very specific powers. So those are the powers I addressed, and I'm going to show you those. So those are powers specified in Section 25 expressly, or in Schedule 11, Paragraph 4. This isn't any of those. This communication isn't an exercise of any of those. And the revenue accept that. They're saying it's not that. It's implied what we've done from either Section 25 and or Schedule 11, Paragraph 1.
So there's no implied power of verification?
There's a power to verify. The question is, while you're doing that, what should you be doing with the claim? So when I said the revenue can say, in Section 25, you've claimed this input tax, we want the money, we can pay you subject to conditions, including you've got to pay us that back while we verify.
Is that fiscally neutral, insofar as if you have an inflated repayment claim and there's an obligation on the commissioners to pay, that's going to benefit the trader who puts in an inflated claim and is not fiscally neutral as between different traders?
My Lord, if it's an inflated claim, there are provisions dealing with dishonesty or penalties.
I'm not suggesting dishonesty. All I'm suggesting is that somebody has made a mistake and they put in too large a claim.
And then Section 25 tells HMRC what to do with it, which is they can ask if they think the claim is wrong for evidence. And dealing with the point made by my Lord Hamblin, that's specific in Schedule 11, paragraph 4. It says that. Or they can ask for security, or they can pay subject to conditions, including saying you've got to pay the money back if you haven't made it good within a month. They can do all of that.
You said that there's a power to assess. I think you haven't shown us an express power, so that has to be an implied power, doesn't it?
No, the power to assess would be in Section 73.
Right.
And where's the power to verify?
Sorry, to verify. I meant verify.
Oh, did you mean verify? The power to verify would of course be implied, but that's implied for instance, in Schedule 11, paragraph 4. There's no difficulty there. Because what that says in terms is that the revenue can say, before we pay you, you've got to show us evidence.
Right. If there's an implied power to verify, why doesn't one get the time to do that from implication as well, i.e. from public law? The power is implied from public law. Why isn't the timing for exercise of that power also implied from public law?
I don't accept the powers given by public law. The power is given, the power to verify is given by the proper construction of Schedule 11, paragraph 4.
Right. That happens with most public law powers. Most powers are statutory.
Well, I understand that.
Okay.
But as a point of construction, so yes, public law will bring in notions of proportionality, so on and so forth. There's no difficulty with that.
Okay.
If you're interrogating and you're asking, well, what is it that tells me as a matter of construction you've got the power to verify, you don't just have to pay automatically? The answer is that's interrogating the specific provisions of Section 25 that I've drawn your attention to, and I'll show you, paragraph 11, little 4, and in a way addressing the point raised by my Lord Stevens. It'll say, well, where does the balance of convenience lie? Answer, Section 25.3 says, you either withhold payment if there have been no VAT returns. That's Parliament saying that. If there are VAT returns, you do pay, but you can pay subject to conditions, including you've got to pay us the money back. In the meantime, doing what? Verifying the return. There's no difficulty there, because the power to, for example, assess the correct amount of VAT, that carries with it the notion that there is a correct amount, a platonic amount of VAT that ought to be paid, that can be reclaimed by, for example, assessment. So there's no difficulty in accepting, and of course I accept, that the revenue have to verify any claim.
I mean, I come back to my question. Since you accept that the power of verification is something implied in the Act, we can debate the role of public law, but implied against the background of public law, why isn't the timing in which that power has to be exercised not also given by that same source in implication from general public law?
Because in looking at, which is what I'm about to show you, Section 25 and Schedule 11, paragraphs 1 and 4, you will see that Parliament has constructed a regime as to what HMRC are supposed to do. And so that militates against the proposition that there's this implied power to step outside that regime and communicate to the taxpayer, we've simply decided, or we're looking into whether your claim is good, and suspending the time limits in Section 73 while we're doing it. Can I show you? Because I think this is the best way to meet the point raised by three of your lordships now. Now, first looking at section 25. And that, I'm hoping, is page 7 of the electronic bundle.
Page 7.
Of the authorities bundle, my lord.
1335 electronic.
Yeah.
We seem to have a separate electronic authorities bundle, not integrated into the main bundle, or at least I do.
Mine is all one bundle.
Oh, okay.
A bundle containing about 2,500 pages.
I've got that, and I had a joint bundle of authorities as well.
What page is it?
What 1335 electronic is section 25 of the VAT Act.
My Lord Hodge does not know how grateful I am. Anyway,
Yeah.
please may the court look at
That's
that.
the same. Yeah.
Now, I said, section 25 is the provision dealing with where there's input tax. Little 2 is what tells us when you've paid input tax, you get a credit, so you deduct that from your output tax. Little 3 is what I said was mandatory, because if you've got an excess of input tax over output tax, the excess shall be paid. Now, this is beginning to answer the points raised by my Lord Stephen, my Lord Sales, and my Lord Hamblin. Because this is Parliament telling us what the regime actually is. So that's the default position. You get your money. Let's say you've got an inflated claim, or the revenue don't know if your claim is good. What happens next? Little 4 is all to do with holding your claim over to future periods, so we don't need to dwell on that. Little 5 gives a right to withhold if there's a failure to have delivered VAT returns. So that's the only express right to withhold. Little 6 that's what tells us, and it's the very last couple of lines, that where someone has made no taxable supplies in the period concerned or any previous payment, credit shall be made subject to conditions, if any, that the commissioners think fit to impose, including conditions as to repayment. So those, even the revenue's power to impose conditions, including repayment, is very, very specifically circumscribed. They only apply in the case of a person who's made no taxable supplies in the period concerned. Now that's why the space that my Lord Sales, I think, is addressing about where public law would control, police the exercise of powers, that space is occupied by section 25. Parliament saying in little 3, default position, repay, pay it. That's the shall. You can pay subject to conditions, including repayment, but only in very specific circumstances. That's little 6.
But there's only, I'm just reading this for the first time, but the power to repay, the duty to repay, is conditional on either no output tax being due or the amount of a credit exceeding that of the output tax. So unless the commissioners have established that one or other of those situations exists, I wouldn't have thought they were under a duty under subsection 3.
That's the duty to verify. I've got no problem with that. But we're in a place where first of all, we're in a place where if they think insufficient output tax has been declared, they can assess. That there's a specific power. That's section 73. I'll show.
But before you get to that, they've got to verify. So I mean, I think that the point my Lord was just putting to you is that you don't get help, it might be said, from subsection 3, because that's just the liability after it's been verified that that's the true amount. But there's a prior stage where the revenue have to go through a process of looking to see, well, is that the correct amount? And are these conditions satisfied in 3?
Well, that would be true. That is true. And then you ask, well, where do they get that power to police that verification from? So the power to look at the return, to interrogate it and apply the law to it, I'm not saying, nobody's saying they can't do that. They have to do that.
Right.
But in policing it, in enforcing their view of it, where does that power come from? And I'm saying Section 25 gives examples of those policing powers. You've got those, and it's quite clear when they can be exercised and under what conditions.
But I mean, just if I may, just looking at subsection 6, that's not, if you like, occupying the whole territory. That if you like, takes away in certain circumstances from the powers that the revenue would generally have to verify and make payment, because the first limb of it restricts repayments being made if certain conditions haven't been satisfied, but it doesn't say in what other circumstances a payment may not be made if the verification hasn't been completed. And the second limb of it seems to me to be a very specific power, which doesn't occupy the whole field, doesn't tell the revenue what to do in all circumstances where it's seeking to verify a claim.
I wonder if I could answer this point in this way. The way that my Lord Sales has just put it is you start from the default position, the revenue doesn't have to pay anything until and unless it's verified. And that's why little 6 doesn't help me, because that's, as it were, cutting down the general right to not repay until it's verified. That actually does shine a light on this issue. That's what I'm saying is simply wrong. Why? Because VAT, and this is, I think, common ground, is a self-assessed tax. So the assessment, literally the self-assessment, the self-computation on the VAT return, and for your note, it's now Article 206 of the Principal VAT Directive. It's replicated in Regulation 25 of the 1995 VAT regulations. What that tells you, because it's a self-assessed tax, is that's the assessment that stands until and unless it's disturbed. It's done by the trader themselves. Of course it is. And that's why there are penalties and misdeclaration penalties and that whole regime if you get it wrong either recklessly or worse. And you get that because Article 206, as I say, it's replicated in the in Regulation 25. What that says is there's an obligation to make a VAT return and pay the VAT in that return. That's what self-assessment is. It's not simply filling in your own tax return and saying, well, if it's wrong and different to a Platonic correct number, the assessment has no legal force. The self-assessment, that's true of direct tax. The self-assessment is the self-computation by a taxpayer to say this is the assessment of tax. If you're going to disturb it, you've got powers. Now that's why I say, in response to my Lord Sales, little 6 isn't cutting down anything. The trader has said, I want input tax back. This is the assessment. That's why little 3 helps me to say, you need to pay me, unless, because I'm telling you what the output tax is. I've assessed it. If you think it's wrong, then absolutely exercise those policing powers, those interrogation powers that you, the revenue, have got. That's what self-assessment is. And that's why there are, I've said it already, fierce powers to police mistakes made by the taxpayer in that self-assessment. Yeah. In direct tax...
But when subsection 3 speaks of output tax being due, or the amount of a credit exceeding the output tax, that is talking about what you describe as a platonic entity. It's not talking about what the person has written down in their return. It's talking about what is actually due, is it not?
No, I don't accept that, my lord, because if the revenue thought the output tax was wrong, so let's start with my proposition.
Well, if that's right, then there's no process of verification at this stage at all. I mean, is that what you're saying? Under 3, the terms of a return in themselves give rise to an obligation by the commissioners to pay the taxable person.
Yes, I am absolutely saying that, subject to the policing powers in Section 73 for assessments, and subject to these other conditions. That's why they're there. So that's why I'm saying that the point raised by my Lord Sales is actually central to this issue. Because they're disturbing what would otherwise be a self-assessment by saying, I know you've assessed the output tax as X, the input tax as Y. That's exactly what you've done.
There was a duty to make payment on the assumption that the return is correct.
Yes, and then subject to an assessment to say, but you know what, we've got that wrong. Or, Schedule 11, Paragraph 4, make payment subject to security. Or Schedule 11, Paragraph 4, which qualifies this Section 25, little 3 duty, give us more evidence. If the court looks at it, I'm going to give up on page numbers, but Schedule 11, Paragraph 4.
Don't give up, please.
It's not for council to give up on page numbers. It is for council to give us we work with an electronic bundle. But Schedule 11, Paragraph 4 is on 1369. I'm
very, very grateful. And I deserve that scolding from my Lord Hodge, and I accept it. So, if you have it, you'll see that it's not an alarming proposition, because that duty in Section 25(3) is subject to these conditions that of this, what my Lord Sales would call verification evidence. But that's not what these communications do. What this court read.
So what are they supposed to do whilst they're waiting for the evidence?
Well, they don't have to pay until they do, because if they ask for evidence, that's a condition of allowing or repaying input tax. There's no problem there.
So they're allowed time, so obviously there's a period of time before they obtain the evidence. Are they then allowed time to consider the evidence?
Yes, my lord. And there's no difficulty with that at all, because if they write to the taxpayer to say, you've made an input tax claim, we're not going to pay it until you've given us evidence, because we don't think you have.
But is this not... I'm sorry, I thought you were saying that 4.1, under 4.1, they still have to pay, but they...
No, I wasn't saying that. I'm saying 25(3) says you've got to pay, subject to 4.1 that says we don't have to pay.
Okay.
Right, but I'm still a little bit confused. 4.1 just says they can impose a condition requiring production of evidence. Okay, They do that, they then get the evidence.
Yeah.
On your theory, they have to pay immediately because the condition's been fulfilled. They don't get a chance to look at that evidence.
Well, my lord, then you can do some work, because I'm not saying that. You can do some work on the production of such evidence. I've got no problem with the proposition that that includes production and consideration. Because the production...
So I'm so sorry to interrupt, but where are you getting that from, if not general implication from public law?
No, that I think is a question of necessary implication as a matter of pure construction, a Costel type necessary implication to make that work. The mere production of evidence to say here it is makes no sense. It's empty unless that also carries with it a reasonable time to consider that evidence.
So that's a condition precedent, is it, as opposed to a condition subsequent?
Yes, I'd say so.
Right.
Because what this regime is saying is, in a world where VAT is a self-assessed tax, that's the right answer until and unless it's disturbed. How can it be disturbed?
What happens if they don't, I'm sorry for interrupting, what happens if they don't know what the evidence is that they want to obtain, and they just say, well, you know, we'd like to have a look at your books, or whatever. How does this differ from this case? Why aren't you saying, well, they are asking for evidence in this case?
Because that's not what that letter says.
Yeah.
It simply isn't.
So if they rephrase the letter, everything would have been perfectly okay.
Yes, but that's not a trivial observation.
But let me understand it absolutely clearly. If they had said, we want to have evidence as to your as to your accounts before we repay input tax, that's the end of the case.
Yes, because we wouldn't have been having this complaint.
Yeah.
We might have appealed it, but the reason I'm saying that's not a trivial complaint is that, it's a phrase I've used before, it's not a game where the revenue can say, here's a letter. It doesn't say it's not what it says it is. You don't know that it's not what it says it is. We're not actually asking for evidence. But you're not going to get your money back. The reason that you've got this regime, which says we've got a self-assessed tax where the trader is tasked with making the first assessment, and it's that assessment which is then disturbed. That's when the question arises. That's the sharp end, the business end of this submission. How do they disturb that self-assessment?
I thought they were constantly asking for evidence as to the amount of output tax that was being ascribed to goods as opposed to exempt services. I mean, if one thinks in terms of what was going on, that's exactly what they were doing. They were asking for evidence about output tax.
Not on the face of this letter. On the face of this letter, the one I've shown you, what they've said is something different, something other, which is we're making a protective assessment. They're not asking for evidence.
But the FTT found the delays were due to your client being unresponsive to requests for information. So that was obviously going on. Mm.
It was going on. I'm not defending that. But if they wanted to progress matters, they could have made a best judgment assessment, as they did in Appeal 1 on the other issue. Or they could have made an information notice. And there are provisions under Part 2 of Schedule 36 of FA 2008 to make compulsory visits and inspect records and so forth. Our complaint, what this court has to decide, is that letter that says it's a protective assessment. And because it's not a game, if it had said something different and something other, we would be in a different world. That's right, that's true, but it's not a protective assessment. Does it disturb the self-assessment made by the trader? That's the question. Is it a legitimate mechanism to disturb the self-assessment made by the VAT trader? And I've said the specific duties on HMRC on receiving that self-assessment to do with the repayment of excess input tax, they're found in section 25. So the default position isn't the revenue can do what it likes subject to public law, albeit cut down by section 25. The default position is that the self-assessment is good until and unless it's disturbed. Hence, penalties, sometimes very fierce penalties, for getting it wrong when you shouldn't have.
I do apologise for interrupting again. The self-assessment is good unless until it is disturbed or unless until they ask for evidence.
Yes. And that is not a starting proposition. That's exactly the world we find ourselves in direct tax when pay and file came in. And it's a world we always had when for VAT. We operate in this world where well, I've said it now, we've got an initial assessment, happens to be made by the trader, because that's a convenient compliance mechanism. But it's still an assessment.
Right, but if all that you need to do to displace the assessment, as you say, is say, well, I'm not going to take that at face value, I want to see some evidence, which must happen in millions of cases, then I'm slightly struggling to see why the revenue haven't done sufficient to displace the assessment, as you say. Because as Lord Hamlin points out, the factual circumstances are ones of the revenue saying, we're not accepting all this at face value, we want to understand what's going on, we want more evidence. Against that background, why wouldn't one simply understand the letter that you've referred to, although it uses the words protective assessment, as them basically saying, we're not accepting your self-assessment at face value because we've got this ongoing process where we're trying to get to the bottom of it, and at the moment we think that your figures are wrong, and here's our best guess at the figures that we think are right.
Because that's not what they've done. There are time limits if they wanted to make a real assessment, a proper assessment. They're out of time for those. What that letter says is your figures are simply wrong. They're not asking for more evidence.
But they already had asked for more evidence, and you, with the responsibility for self-assessment, or your clients, chose not to give it. That's the whole background to this correspondence in Appeals 2 to 6.
But then the HMRC are in a position to say what they should have done is fix an assessment to say, one, I've given the court the list of all the things the revenue could have done if they'd done it in time.
But they didn't have the information to make a definitive assessment of their own. I thought that they were asking for information from DCM with a view to doing that.
If the revenue had wanted further information to make an in-time assessment for these appeals, which is the subject of this issue, Appeals 2 to 6, they could have made information notices. They could have exercised the powers, all their powers that they do have under Schedule 36 of FA 2008, and then made an in-time assessment. They could have done that. There was nothing stopping them doing that.
No, but did they have to?
Well,
I mean, looking at paragraph 4.1, it seems clear that the legislature recognises that the revenue might, from time to time, wish to verify a self-assessment that's come in from a taxpayer.
Within the time limit specified by Parliament with the different policing mechanisms they've got.
All right.
That's not a surprise. There's no, so in this case, for example, there's no dishonesty, so there's no 20-year time limit, nothing like that. What the revenue had, like they do for every trader, everywhere, are a set of powers to say, this is your self-assessment, for one reason or another we're going to police it, and then they've got time limits. they've got time limits, depending on the context of what they're quarrelling with, to either fix an assessment. I'll get on to the other issue in a minute. But until they've done that, what we're interrogating here is, on the basis that there is this self-assessment, are there time limits? First of all, how do they displace it? And secondly, if they do displace it, how long have they got? And that's why, in response to my Lord Hamblin, absolutely what the revenue could have done is to say, we don't believe this, we want more evidence. And if we're going to do something about it to protect ourselves, yes, if you're telling us we have to pay you, then assess you for the money back, we'll absolutely do that. And if we do that, you'll have to actually, if you're going to appeal against that, give us that very tax back, subject to hardship, to lodge that appeal.
The right to repayment, that's paragraph 4.1a, is that right? Right.
Yes.
To impose repayment, yes.
So there is a regime. The revenue are not unprotected if they do their job in time.
But they have no power to impose conditions in the current circumstances where the taxpayer was, or the trader was making taxable supplies. So 25(6) doesn't apply to a taxable trader in the period in question.
No. So what they could and should have done is pay, then assess to best judgment, if that's what they thought the right answer was, and then there would have been an appeal. Because in making that assessment, if there's an appeal, I've said the taxpayer would have to have found that very money and lodge it as part of the right to make the appeal in the first place. There's nothing odd about the regime that I'm giving to this court.
Well, can I ask you this? The regime that you've just mentioned seems to have built into it the possibility for the taxpayer to string the revenue along, not give them the information that they would actually need to make a definitive assessment of their own until they're out of time to make an assessment.
No, I don't accept that. The revenue have got a job to do, and they've got investigative powers to make sure that they get enough information to make a best judgment assessment in time. And if they're doing their job, that's exactly what they'll do. And if the taxpayer's been reckless or dishonest, there's penalties. So what I'm saying is not any sort of license for a taxpayer to behave badly. The revenue are in a position where they can ask for whatever information they like. If they don't get it, they've got information powers, they've got investigative powers, and they've got a right to make an assessment to best judgment within a year of getting the evidence.
So you seem to be saying that what the revenue should be doing is exercising powers to compel production of information from the taxpayer in order to make an assessment. Is that right?
Yes, my lord. What else would the revenue do to a taxpayer who's not actually complying with their...
Ask them. Please give us evidence.
And if they don't get it, then they've got powers to say, I'm going to make you.
Right.
That's, I think...
So in effect, you seem to be saying use of those powers should actually be the first port of call. If they don't get everything, when they ask the taxpayer, please give evidence, and they're not immediately satisfied by the evidence that is produced, rather than have a dialogue with the taxpayer, they issue compulsive notices. That's the way it works.
No, that's an unfair gloss in my submission. The revenue have got time limits in Section 73 as to when they can make an assessment, and so it's not some sort of inter oram threat to the taxpayer to say, give us the evidence tomorrow, and unless you do, we're going to start issuing information notices. They've got time. They've got time, which is 2 years, 2 years after the end of the prescribed VAT accounting period, or 1 year after they've got the evidence. And
just so I understand what you're saying, do you have the references to the compulsory powers that you're now referring to? Just so for our note.
FA 2008, Schedule 36, Part 2.
And what page number?
No, they're not in this bundle. Right. Because they're not part of my appeal.
All right, I didn't get it when you rattled off the...
Oh, I see.
Can you just give it again?
Yes, FA 2008.
Yes.
Schedule 36, Part 2.
Part 2.
Those powers are?
investigation, right to enter premises, and they apply to all taxes. You'll find that in paragraph 63 of Schedule 36, including VAT. But more relevantly, and this will actually bleed into the other issue, if the court please looks at section 73.
Electronic 1338.
I'm very grateful.
So 1338.
38.
Thank you very much indeed. Thank you.
Section 73 is the power to assess. So the court will see that if it appears to the commissioners, and the cases say, well, that's a matter of opinion, they can assess. What can they assess? Under declared output tax, no question that's already embedded in little 1, or a repayment or refund of VAT, including the excess input tax payment if you look at little 2, little b. So there is no difficulty with HMRC being faced with a claim to say, actually, you self-assessed. Having looked at it, we think that's wrong. We're going to disrupt that assessment by assessing you.
But surely Section 73(1) comes into play after a process of verification has gone through, because it has to appear to the commissioners that such returns are incomplete or incorrect. They may not know. That's why they're asking for evidence.
And they've got the powers to ask for that evidence.
Right, so it keeps coming back. You seem to be saying that they should be using compulsory powers almost at the drop of a hat.
I'm not saying that.
If they're not immediately satisfied by the evidence they've got from the taxpayer, they know that they've got a time limit running against them, only 2 years, as I understand, only 2 years to sort this out. They better be using their compulsory powers straight away, because otherwise they're going to be time barred on your theory.
And I've said that's an unfair way of putting my submission, because it doesn't have to be immediate. They will be telling the taxpayer, we want evidence, but like all public authorities, including the revenue, if you don't give us the evidence that we need, we do have powers and we'll use them.
Right.
And that's a perfectly sensible dialogue.
Yes, sorry, thank you.
And the reason this matters, and this is a bridge between the two issues in this case, is because if you look at little 6, please. Well, little 4 tells you, first of all, you can have multiple assessments.
Before leaving 73(1) and 2, is the amount of VAT due from him.
Yes.
And if there isn't any amount of VAT, if it's a lower amount of repayment, then how do you make the assessment?
Little 2.
Well, that's where it has been paid or credited.
Yes, and that's my point. That ties in with section 25(3). So they've paid it, and now they're assessing for it back. It meshes completely with 25(3). And if they've used paragraph 11(4) to say we need more evidence, they haven't paid anything at all, so there's nothing to assess, if that's what they've done.
It's a very odd, I mean, if this is right, it's a slightly surprising system that there's a duty to pay the trader who's failed to produce the evidence, who's failed to, at any rate, to satisfy the commissioners as to what he's due. You're bound to pay him the credit sought in his return, and their only remedy is to rank as a creditor against him under this provision in the event that it turns out that the money wasn't actually due to him.
there would be no difficulty for Parliament to have given an express power to withhold payment, just like you saw in section in 25. If there had been no VAT returns, the revenue got an express power to withhold, not to pay at all. They've got that power, but only in a specified circumstance. So, Parliament could extend that power, not just for VAT traders who haven't made VAT returns, that's section 25.5, but to any trader. It could have done that. But Parliament hasn't. And our complaint is the revenue can't simply take that power. And it doesn't leave a hole in the protection of the revenue because they've got this power under section 73 to assess. So there are squads of cases from the Court of Justice that say, of course, if domestic law has given the fisc a right to withhold payment of VAT, then so long as that's exercised proportionately, etc., those powers are good. The point I'm making is that that power doesn't exist here. Parliament hasn't given the revenue that power. And if you're asking, is it a necessary implication of what you see in section 25 or paragraph 1, care and management, that's not a necessary implication. You don't need that power to make those powers work. What the revenue's done, and this actually taps right into what my Lord Sales is, his point. The revenue saying this is inconvenient, this is annoying. So actually, it's far more convenient to simply not pay and make these protective assessments, which aren't assessments. And my response is you can't do that. If Parliament had given the power to the revenue, then we wouldn't be here. That's true. And if you're asking,
I have difficulty in just defining it as being annoying and inconvenient to the revenue when it would be fiscally not neutral for the revenue to act as a creditor for people who don't put in proper returns.
but my Lord, I think that's unfair on DCM.
Well, I'm not saying in this case, but just as a general principle, if someone puts in inaccurate returns and compels the revenue to be its to basically to fund it, that is not fiscally neutral. Gives an unfair advantage to traders.
But my Lord, that's a proposition that says your returns have to be right and there are policing powers, including penalties, when they have to be corrected. And nobody's arguing with that. So the real burden of your Lordship's proposition there is, do the exercise of assessment powers and penalty powers, which are a function of the behaviour of taxpayers, do they ensure fiscal neutrality at the end of the day? And my respectful submission to that is yes, they do. So don't accept anything I say offends fiscal neutrality.
It's my fault, but I'm not sure that I followed your answer to what I was asking you about section 73, subsection 1. Do you accept that in where it says, where it appears to the commissioners that such returns are incomplete or incorrect, that's looking at a stage after some process of verification has been gone through by the commissioners?
Absolutely.
Right. Okay.
They've got the VAT return and any evidence, whether they've asked for it informally or through specific powers. Yes, absolutely. Nobody is quarrelling with the proposition that the revenue gets to look, in fact has to look, and interrogate the VAT returns. The question is, having done that, how do they go about quarrelling with the self-assessment?
But we're dealing with a situation where they're in the middle of that process.
Well, my lord,
I understand your criticism of the language in the letter of protective assessment, but I mean, certainly the impression I have from the facts is that the revenue was at that stage still trying to get to the bottom of what the true position was, which they would have to do before any question of them issuing an assessment under Section 73(1) would arise.
And if they wanted to do it properly within their powers, what they should have done is within time for each of those periods, either pay the input tax back and assess that amount back, or say, and this is not, my lord, what the letter says, you haven't given us enough evidence. Yes, there was a dialogue going on in the background, I understand that. But that letter you read, and they're all the same, doesn't complain about an absence of evidence. It simply doesn't. It says the numbers are wrong, we've corrected them. And even that was wrong, because what they were actually doing, according to the evidence of the officer, was saying, I know it says that, but what was really happening was this was us just saying your account's in suspense until we've sorted out what the right number is. So we are actually returning to this point, that in a quarrel with the self-assessment, what can the revenue do? Whether it's output tax, whether it's input tax. Answer, those powers are found in Section 25 or they're found in Schedule 11, Paragraph 1 or 4, and they militate against the proposition that what the revenue can do is not have an assessment, wait till the expiry of the time limit to make an assessment, and then say, well, we're not paying you. And the point that arises repeatedly in the exchanges I'm having with my Lord Sales is, yes, but this was DCM's fault, and whether you describe it, I think, unfairly as stringing the revenue along, or any other reason why.
Just to be clear, I wasn't specifically saying that DCM had done that, but I was just saying that on your theory, they seem to allow for a taxpayer to have that opportunity.
And the revenue has specific policing powers to find sufficient evidence to make a best judgment assessment. They've got those.
Right.
You're no doubt bearing in mind the time.
Yes, I know. But I can close my submission on this issue by saying, as a matter of, and you've got this from a written case, as a matter of, and this, for an implied power, it's got to be a necessary implication to make, that's Morgan Grenfell, not a reasonable implication, a necessary implication, that what you've seen in Section 25 or what you've seen in Schedule 11, Paragraphs 1 or 4 means that the revenue can write to the taxpayer, putting their right to a credit in suspense in terms which are inaccurate. And it's not just a question of language, and I've said it more than once, it's not a game, it's not saying to the taxpayer, I know we didn't ask you for evidence, but come on, you must have known that's what this letter meant. To make the Section 25 powers work in a self-assessed world, you don't need to imply the power the revenue says it's got. Care and management, the same. They're very narrow anyway, that's Wilkinson. But Paragraph 4 tells you the revenue do have power to say, give us more evidence before we're paying you. If they had wanted the additional power, the sort of power that other member states do have, to extend the power to withhold the payment of input tax that I showed you in Section 25(5), then Parliament would have given that, and Parliament can give that power, but they haven't got one of those. And that doesn't lead to the terrible world envisaged by my Lord Sales, which is, instead of having a sensible dialogue with the taxpayer, you say, I'm threatening you now. No, you have that dialogue, but if you're bumping up against the time limits for assessment, you say to the taxpayer, look, we've been having this dialogue. You haven't given us the information we wanted. We're going to make a best judgment assessment, and insofar as to do that, we need further information. If you don't give us what we want, we've got powers to get it.
Can I just ask you, just in a sentence, why you say any implication here has to be a matter of necessary implication?
Paragraph 45 of Morgan Grenfell. As a matter
But
of
that's
authority.
dealing with an argument that a power was implied which would interfere with a fundamental right, in that case, legal professional privilege.
Well, response number one, why is it any different here when you're dealing with policing and assessment powers with HMRC? Response number two, as a matter of an implied power, what we're asking ourselves is this a power, looking at the code that we've got in front of us in the VAT Act, that is consistent with that code? Because the implied power is needed to make this code work properly. The answer is no. We've got the powers they need. And that's why I say that phrase, necessary implication, rather than reasonable implication, is good for all, in my respectful submission, implied powers from statute. But here, I'm going further. I'm saying the power the revenue say they've got to issue these letters three years after, that's militated against by the code we've got in Section 25. With your permission, I'll move on to the other issue, which is actually equally profound, but it's short.
Yes, I mean, Lord Hophouse's dictum at 48 is this passage begins in paragraph 44 of his judgment, which is citing the principle of legality from Lord Hoffman in Ex Parte Sims, and then applies that on the basis that that Sims was concerned with human rights, and this case was concerned with, where he says the protection given by the common law to those entitled to claim legal professional privilege is a basic tenet of a common law, and hence this requirement of a necessary implication.
Yes, my lord, but the read across to this case is actually perfectly short. The principle of legality, the powers that the revenue can use to disturb an assessment, is every bit as strong and as every bit as necessary in this case as it is even in cases which are much more highly charged, dealing with human rights. And the court's seen the point. The letter that they got, the letters plural that they got, said these were protective assessments. They weren't that. So if Parliament wants to give a power to the revenue to do this, she can. I'm saying she hasn't. And you don't need that power to make Section 25 work, to make Schedule 11 work, whether it's paragraph 1 or paragraph 4. And the revenue are protected. Continuing to look at Section 73, I'll take the facts short.
So are we now on the first issue?
Yes, yep. Exactly. The facts short are these. 1, HMRC wrote a letter in June 2003 saying that for output tax purposes, when they made sales of both spectacles and these eye tests to customers, it should be what they called an FCA method. It should be on a 36-64 split.
And a page number, do we have that?
We do.
Oh, no, don't take up time on it. I'm sure we'll find out.
Well, I will give you page numbers when in reply if I need to. 2. There was a meeting on the 29th of January 2004 between the HMRC and PwC where there was a quarrel because HMRC had said, yes, 588, 488 of the meeting of the electronic bundle, where there was a quarrel because it was quite clear that for the periods we're talking about, DCM were not using an FCA. They were doing their own system of trying to apportion these charges.
Which they represented was a proper, separately disclosed charge system.
That's what was held, because they were fighting about it, and that was one of the issues before the FTT, whether it was a good system or not.
Yes,
and
but DCM's position was that there were only minor differences between the revenue and themselves as to whether the system they operated was a good system.
Exactly right.
And that's what there was deadlock on. There wasn't an agreement. We see that in 488. Towards the bottom of that note, the third last paragraph, I think.
That's exactly right, my lord. But what there was deadlock on was this issue as to whether they were or weren't using the FCA, and they weren't, because the FCA and 3664 split, they're the same thing. They're synonyms. So the revenue have another visit. So they know this as at January 04. They have another visit in August, 31st August 05, and they discover, and there's no defence to this, that the input tax, that element of the VAT return is wrong. And it's a very simple point. The revenue say, well, we're assessing you as at 20th October 05, and this assessment's got two features. One, you've not been using for output tax purposes the 3664, but they knew that, but we're going to assess you to put you onto.
And I'm so sorry, do we have the page for the 20th October 05 assessment?
Give me 1 minute, my lord. 515, my lord.
515.
I'm very grateful, and I'm grateful for your patience. All right, so...
Wasn't it only at the meeting on the 31st of August that they found out that the split was 31%, 38%, 30% and 28%?
That's right, and if I go straight to the point here...
But they didn't have that information on the 29th of January.
That's right,
and also they didn't know the extent to which, as Lord Stevens says, the extent to which the trader was departing from what had been agreed in the settlement. They didn't know that, nor did they know from the tax returns what element was this element of mixed supply in the total turnover of the group, did they? Because the tax returns would give, I think, a global figure for turnover.
Yeah.
It would give a figure for output tax, a figure for input tax, and a balance due to the revenue or the taxpayer. That's what they get from the return. So they didn't know in a particular taxable period what element of the group turnover was purely taxable supplies, and what element was this mix between taxable and exempt supplies. I think that must be right. And if you apply and no one takes any issue with the approach taken in the Pegasus Birds judgments of Mr. Justice Dyson and Justice Alders, then this was information which was relevant to the assessment when it was made, and that information wasn't obtained before the meeting.
Can I give my response to that by looking at Little 6? And this will also deal with my Lord Stevens' point, because the big message delivered by the court was there were things that the revenue found out in that meeting of August 05, 31st August 05, which they needed to know in order to make the output tax assessment. And little 6 tells you, it gives you time limits. 2 years after the end of...
Sorry, little 6...
section 73, subsection 6, my lord.
Page
1338 still. And I'll take it short because I'm up against the buffers, but you've seen 2 time limits. 2 years after the end of the prescribed accounting period, as defined in section 25, little 1, or 1 year after the evidence of facts. Now, also important is section 77, subsection 6, page 1342. That deals with supplementary assessments. But they've got to be made in time. So the short point is this. Because the revenue knew in January 04 that the 36-64 split wasn't being effected, wasn't being followed, they absolutely could then have issued a best judgment assessment. The precise figures that my Lord Stephen refers to ought to have been the subject of a supplementary assessment that's subject to the same time limits. In other words, refining the initial best judgment assessment.
I just can't understand it. The meeting in January 2004, your client didn't say, well, by the way, we've been using a split of 28% on the majority of these returns. They didn't give the figures. For all the revenue knew, the figures would have been 38%, and that would have been suiting them fine.
Well, my lord, they would have known they weren't using 36.
Well, can I ask this question? Do you accept as accurate legally the approach set out by the courts in Pegasus Birds as to how we approach the interpretation of 73 6b?
Yes. Yes, I do.
Well, in that case, we have to ask where it was the evidence which the revenue official when did the last piece of evidence which the revenue official relied on to make this particular assessment become available to him? And surely the answer to that question is at the meeting in August 2005.
And my response to that is no.
Why?
Because they knew that the FCA wasn't being applied in January 2004. And in answer to my Lord Stephen's point, the whole purpose of section 77(6) is to permit a refinement within time of an initial best judgment. Otherwise, the revenue could wait forever to say, well, we want the right answer, we want the right answer, we want the right answer.
That is a regime which the statute could have put in place, but that is not the regime as interpreted in Pegasus Birds.
But, I mean, my response to that, my Lord, is why not? The revenue has got not just information. They're being told in a quarrel with the taxpayer, we're not doing FCA, and have said FCA is synonymous with 36% because that was the very essence of that letter of June 03.
But I mean, they didn't know what they were doing.
Yeah, quite. Surely that's the start of a process. Well, you're not doing that. What are you doing? Please tell us.
There might be a minor difference. The taxpayer might have been right that their separately disclosed charge regime was almost correct.
But
the revenue didn't know this. What the revenue discovered in August 2005 is that the taxpayer hadn't honoured the deal which it had done, had failed presumably knowingly, to make disclosures as it undertook to do, and was operating a system which was considerably out from the 36-64 split.
And I say that's the subject matter of a supplementary assessment. They knew that FCA 36 wasn't being operated. They did know that. My Lord Stevens says, yes, but it could have been 38 or 40 or anything. But they did know that 36 wasn't being operated. The precise figure, that's a subject of refinement. That's what a supplementary assessment is, and that's why the draft person in section 77.6, that's what he or she is doing. They're saying, absolutely you can refine your best judgment, but don't think you can extend time limits by doing that. And in response to my Lord Hodges' point, that they find out something's wrong, and they've got a year to find out. But they were told.
And it's your submission that approach, they find something's wrong and have a year to find out, you say that is consistent with the analysis in Pegasus birds?
Yes, I do, or it's not inconsistent. And
did they also find out the figures at page 101, paragraph 45, at the meeting in August, or shortly after the meeting in August 2005?
Oh, that's the revenues table, but I think that's both output tax and input tax. And I've said there's no quarrel that the input tax was wrong. I'm not defending that.
And the figures there at paragraph 45 work out what the mixed supplies are to be in the assessment.
Right, but
that is relevant to the application of a 36-64 split. And they are taken from, presumably, the total turnover of the group. They're a subset of the total turnover of the group, and it's to that figure that the split is then applied. Did the revenue have those figures before the meeting?
Well, all I can say, and I'm not going to be able to take this point any further forward, is that what the revenue are not pleading in this case is that they couldn't have assessed on a 36-64 basis without that August 05 meeting.
But they would have been assessing on the 102 million, which is the self-declared, as opposed to the 114 million, which is what they found out. Yes,
but the actual assessment, I've said, it reflects one, the input tax, two, the precise figures on these VAT periods, the 31, the 38, and then the 28, all that. And that's what I'm saying would have been a permitted refinement if it's made in time. That's section 776. That's what it's there for. It's no part of the revenues case that they couldn't have assessed for 36-64 without the August 05 meeting.
Well, can we look briefly at page 2207? And this is Mr. Justice Dyson's statement of the legal principles to be applied to 73.6b. And the third principle is that the knowledge that's referred to is actual, not constructive knowledge. In this context, I understand constructive knowledge to mean knowledge of evidence which the commissioners do not in fact have, but which they could or would have if they'd taken the necessary steps to apply it, to acquire it. And then it goes on in 4 that the correct approach is to be adopted is to decide what were the facts which, in the opinion of the officer making the assessment, justified the making of the assessment, and to determine when the last piece of evidence of those facts of sufficient weight to justify the making of the assessment was communicated to the commissioners. I mean, this is pretty clear statement of the approach to this subsection.
Well,
what you're saying is the revenue could have. They knew that the FCA approach wasn't being applied, and they could have made inquiries earlier. But that flies in the face of the third principle.
let me finish by saying this, because I'll close on this. No, I'm not saying that. I'm saying that they knew the FCA wasn't being applied, and it's no part of my learned friend Mr. Thompson's case that they didn't have actual knowledge of what and needed to get that actual knowledge from somewhere else in order to make the assessment they did. They didn't find anything out.
Well, it is his case, paragraph 45, which we were looking at a second ago. It is precisely his case that it was material that they obtained on the meeting that gave rise to the assessment.
What they found was the precise percentages, not the absence of using 36%.
No, but they needed to know the figures to which to apply those percentages. And that involved stripping out of the total turnover, the turnover in respect of mixed supplies.
My Lord, I really can't make a sensible response to that, because it is nowhere to be found, not in the review letter, not in the confirmation of the review letter, that was ever a problem. So I think I can't respond in any sensible or appropriate way, except to say you will find nowhere on the letter sending the assessment or on the letter reviewing the assessment that was needed from the. I know Mr. Thompson says, oh well, we found out all sorts of things about output tax.
Well, I shall ask Mr. Thompson to give me the page numbers of those particular letters when he makes his submissions, but thank you.
I'm grateful. And unless there's anything else. No, those are my submissions.
Thank you very much, Mr. Ghosh. We're going to take a few minutes to review where we've got to with this. So the court will adjourn and we'll resume as soon as we can in a few minutes' time. Mr. Thompson, we don't feel we need to call on you on the second issue, which Mr. Ghosh was arguing, what we might call the Pegasus birds point. If there is anything in relation to that the revenue are anxious to impart to us, then of course we'll hear you. But we don't need, for our own purposes, we don't need to hear your reply on that. Whereas we do want to hear you on the point that Mr. Ghosh took first.
I'm obliged, my lords. Well, on that basis, obviously, I begin by inviting the court to refuse the appeals on the basis that the interlocutors pronounced by the First Division of the Inner House on the 8th of September 2020 were well-founded in law. So far as the second issue canvassed in oral submissions by my learned friend is concerned, the only matter I could perhaps mention to the court, I think my Lord Hodge had asked for details of some of the correspondence.
Yes. Could you possibly keep your voice up, Mr. Thompson?
Certainly.
You're a bit faint, even for me sitting here.
I'm obliged. So I think I was asked by my Lord Hodge for details of the correspondence that bore upon that issue, and in particular the table that appears at paragraph 45 of the written case for the commissioners. Really, just to give the court the references about that issue arises because of paragraph 84 of the, rather 83 of the upper tribunal, which is at page 185 of the joint bundle. That was the passage where the upper tribunal stated that the calculation had simply been applied as the difference between the amounts declared in the returns and the amount of output tax due on the 64-36% split. Now, the inner house in relation to that issue at paragraph 28, page 144 of the joint bundle, accepted the submission for the commissioners that that was simply wrong. It was incorrect. The table that appears at paragraph 45 of the commissioner's written case is based upon page 472 of the joint bundle, which is part of the documentation attached to the Commissioner's letter of 7th September 2005.
472.
Yes, so that the letter itself, my Lord, begins at page 467. And various tables were appended, and at page 472 there is a schedule of the assessment of output tax, and the first column is the mixed supply sales figures that appear in the table at paragraph 45 of the Commissioner's case. And the short point the Commissioners were making, which the inner house accepted, was the upper tribunal was wrong to say this was all just based on the returns, because the VAT group was comprised of various members, and looking at the mixed supplies in question, one had to see the VAT account, and that's what the calculation was applied to. So those are the references, and that's where the figures come from, page 472.
Am I correct in what I was putting to Mr. Ghosh, that the returns would show the global turnover of the group?
Correct.
It would show their assessment of output tax, input tax, and then the balance between the two.
Correct.
There was no system in the returns themselves to show what was the proportion of the total turnover which was mixed supply, which you've recorded at page 472. That's something you had to deduce from the records.
Correct.
Yes.
And now, since you have taken us to this, Mr. Ghosh will be entitled to go back to it if he wishes in his reply.
So that was just to explain where those figures came from. Turning then to the issue of amendments, and my starting point, Lords, in relation to that would have been to say that the question of whether the power contended for by the Commissioners falls to be implied has to be seen in the context of the taxpayer's necessary concession that appears at paragraph 10 of its written case, which is page 60 of the PDF. And that concession is there is no dispute that HMRC is not obliged simply to pay any amount claimed in a repayment return immediately, and is entitled to take reasonable and proportionate steps to verify that the sum is owed. So,
page what, sorry?
My apologies, Lord. That is at page 60 of the PDF, and there's a similar agreement recorded in the Statement of Facts and Issues at paragraph 7.7, page 54. And I think it's paragraph 7.7 of the Statement of Facts and Issues. So I had taken as my starting point that that was the common ground between the parties, that there is an obligation, that HMRC is not obliged simply to pay a return and may carry out reasonable and proportionate investigations. Having heard the submission the learned friend has made today, that the weight of that submission became, once a return is submitted, ultimately the Commissioners will have to give the VAT credit. And what the Commissioner, effectively, whatever they establish following the process of verification, they have to give the credit. And what they should then do is seek to mitigate the effects of their having given the credit by seeking security or assessing to recover it, having paid, and so on. That was the the essence of the submission made by my learned friend. Now, in my submission, that is fundamentally wrong, because it contains that essential premise that, notwithstanding the process of verification, the credit has to be given. The case for the commissioners is there being a power and an obligation to verify the return. It must follow that if the commissioners arrive at the view that the repayment sought is not due, they will deny the credit to the taxpayer, rather than accepting the credit and seeking to assess to recover that credit. And in my submission, the starting point for that proper understanding of the regime may be found in the judgment of Mr. Justice Lightman in UK Trade Corps. And I wonder if I could take the court to that judgment at page 2253 of the joint bundle. And it's paragraph 18. So paragraph 18 on page 2253 contains a summary of the duty to which the commissioners are subject to carry out a reasonable and proportionate investigation into the validity of claims for a refund and repayment, and a duty to act proportionately in those respects. However, what comes immediately before that is of central importance to the contention advanced by my learned friend that VAT being a self-assessed tax, when the taxpayer assesses himself, his return is what establishes the right to a VAT credit. That matter is considered by Mr. Justice Lightman in paragraph 17 that begins on page 2252 of the joint bundle at the foot of the page.
Paragraph 18 also addresses the question of a reasonable time to investigate.
Well, indeed, and there's another important point in paragraph 18.
Or perhaps you're going to come to that.
I'm going to come back about fiscal neutrality, which was one of the points which my Lord Stevens raised about this notion that a trader who is not, in the view of the commissioners, entitled to a repayment should nevertheless get the credit. But at 17, there's a reference to the running account that's to be kept between the taxable person and the commissioners. And then Mr. Justice Lightman continues, for the purpose of the running account, a distinction must be drawn between claims for refunds and repayments which have been admitted or upheld and claims which have not been admitted or upheld. I shall later consider and reject the claimant's contention that there is no distinction between the two. It is sufficient to say at this stage that for reasons which I will elaborate later, a claim which has been admitted or upheld, and only such a claim, gives rise to a right of deduction. And if the deduction exceeds the amount of tax due, a prima facie right to immediate payment. The right to payment is only prima facie because the commissioners may be entitled to refuse to pay without account being taken of a cross-claim by the commissioners against the taxable person. So that proposition which we see there is, in my submission, correct, that there is this distinction between a claim that has been admitted or upheld on the one hand and one that has merely been advanced on the other. And that takes one to paragraph 18 between letter E on page 2253. The availability and proper exercise of the Commissioner's powers of investigation are essential to maintain the fiscal neutrality of VAT and prevent refunds being made to parties not entitled to them. So the starting point from a learned friend's submission in my submission is ill-founded. That starting point was it is the submission of the return that establishes effectively the right to a VAT credit in terms of section 25, subsection 3. The true position is that the commissioners are entitled to investigate and to verify, and indeed, in my submission, as we'll go on to see, entitled to deny to give the VAT credit which is sought. In answer to questions...
Sorry, just before we leave it, the authority that Mr Justice Lightman cited in relation to reasonable time was a case called Strangewood. Do we have that?
That's not in the bundle, my Lord, no.
Is it? Right.
I pause to say, as I have understood the case so far, this articulation of principle I had not understood to be contentious, but having heard this submission this morning, and this was the point I was about to turn to, when my learned friend was asked certain questions by my Lord Hamblin about the process of verification, the answer given by my learned friend was to refer to section 25 and to look at the powers in section 25. And I wanted just to turn up section 25 in that connection. And if we look at that, which is at page 1335 of the joint bundle, the first point to note in relation to subsection...
I'm sorry, can you give me the page number again?
My apologies, my Lord. Page 1335. And it's...
I apologise, it was me doing something else.
And section 25. And in relation to subsection 3, one of the questions which the President and the Chair put to my learned friend was, this effectively presupposes that it is indeed the case that no output tax is due, or alternatively that the input tax exceeds the output tax, so that there is a VAT credit. I say that's correct. That is what the section presupposes. And when one looks at the various provisions that are in section 25 and elsewhere in the Act, in connection with the steps which my learned friend says effectively exhaust the field, these are all steps that arise in circumstances where the commissioners have had to accept there is a credit, there is a VAT credit, and they're then trying to stop the credit being paid by, for example, assessing. And that's why the court was taken by my learned friend to section 73 of the Act at page 1338, subsection 2. And subsection 2 of that section, in any case where for any prescribed accounting period there has been paid or credited to any person, either as being a refund or repayment or refund of VAT, or as being due to him as a VAT credit, which is what we're talking about in section 25, subsection 3, an amount which ought not to have been paid or credited, reading short, the commissioners may assess that amount as being VAT due from him and notify it to him accordingly. So essentially what the taxpayer is saying is the commissioners do have an entitlement, indeed an obligation, to verify. And even if at the end of that process of verification they reach the conclusion that the VAT credit is not due, on my learned friend's analysis, the credit must still be accepted, and then the commissioners must take their chances by exercising the various remedies available to them, effectively to undo the giving of the credit that they have already decided shouldn't be given in the first place. That, in my submission, is the weight of the submission for the taxpayer, and it plainly does not make sense. I mentioned to the court a moment ago the paragraph 17 and 18 of the judgment of Mr Justice Lightman in Trade Corps. Those paragraphs are concerned with repayment returns. It's worth drawing a comparison in my submission with the position in respect of payment returns. In other words, where the taxpayer submits a return that shows a sum due by the taxpayer to the commissioners. And in that situation, the Court of Appeal has indicated that the submission of a payment return is an admission of a liability to pay that amount of tax. And that's the case of the Commissioners and Chamberlain, paragraph 26, at page 2295 of the joint bundle.
So the number again, sorry.
So it's paragraph 26 of the Commissioners and Chamberlain and it's page 2295 of the joint bundle. So in the case of a payment return, I would accept my learned friend's analysis that the return creates a debt due to the commissioners, but the corollary is not correct, that the submission of a return, which is a repayment return, does not give rise to the VAT credit in the way which is argued for by my learned friend. And that comparison between payment and repayment returns in my submission is a helpful one to draw, because in the case of a payment return, if the commissioners accept that return but take the view, after further consideration, that an additional sum is due to them, in other words, they are the creditor, then they have to assess under section 73. And that would be section 73, subsection 1. And there are time limits for them to do so. So they're the ones who want more money from the trader. The onus is on them to do something about it, by assessing. In the repayment return situation, though, the submission of the return doesn't create the debt. If the commissioners indicate to the taxpayer, as they did here, that the commissioners were not accepting the claim for a VAT credit, it's the taxpayer who says he is owed money by the commissioners. And if the taxpayer does not like or accept the decision of the commissioners to deny him the VAT credit, it is for him to appeal against that decision.
And can he do so irrespective of whether it's input tax or output tax? So that if the only alteration, only amendment to the return that is made by the commissioners is to the amount of output tax, can the trader appeal?
Section 83 applies to both situations in relation to input tax and output tax. So once there is the decision of the commissioner saying the VAT credit that is being sought is not being given, that is a decision that is appealable under Section 83 and was accepted by my learned friend. That indeed is the appeal that the taxpayer marked.
Do we have Section 83 in the bundle?
We do, my Lord, yes. It's I'm ascribing to the joint bundle my own version of the joint bundle, which is I've added Section 83, so I'm afraid it's not, but I can certainly...
It isn't there, yeah.
It isn't. I can certainly ensure that a copy is given to the court, but it would be Section 83, subsection 1, B and C would deal with output tax and input tax.
And as I understand, it's unfortunate we don't have the text, but the text includes a right to appeal against a decision. Is that the language used? And you say that if the revenue simply, in effect, tell the taxpayer, we don't accept your self-assessment in a repayment return, that will be a decision and the right of appeal follows.
Correct. Although subsection 1, B and C deal with B deals with the VAT chargeable on the supply of goods, and C deals with the amount of any input tax which may be credited to a person.
Okay.
So as soon as the commissioners say we're not accepting your claim for a VAT credit, that's a decision which is appealable within the terms of Section 83. So,
but you can't appeal if there's a delay in them coming to a decision about that. You can only bring judicial review proceedings.
That's my submission, that if we're in the territory of an implied power of verification, and indeed, I say the implied power to refuse to give the tax credit, the VAT credit that is being claimed, that's subject to control on public law grounds. And as the First Tier Tribunal noted in this case, there was never any proportionality, unreasonable reasonableness challenge and so on in the present proceedings.
I notice that I was just following up the Strangewood reference, and I see it's a case that was cited by the Advocate General Fennelly in a case in our bundle called Molenheider.
Yes.
Is that case of any relevance to us?
Well, Garage Molenheider underpins the proposition being advanced by Mr. Justice Lakeman at paragraph 17 and 18.
Yeah. And it seems to be saying that there is an entitlement to retain sums where there is a question as to whether repayment is due, but that the whole thing has to be subject to the ordinary European principles of proportionality.
Yes. Correct. And where the parties on this particular issue part company, it appears in my respectful submission, is the submission which has been made this morning by learning from Mr. Ghosh is that all of the necessary apparatus for the commissioners is to be found principally in section 25, but also in schedule 11. And he then made reference to investigatory powers under the Finance Act and so on. And all of that presupposes that we have reached the stage of accepting that a VAT credit has to be given, even if the commissioners don't think it's due. And my submission is that's not a sensible reading of the statutory scheme. If there is a power to verify, it must include the possibility that having undertaken or while that exercise is ongoing, the commissioners take the view they are denying the credit.
Yes. I don't know if possibly after lunch it's worth taking us to this case, because it seems to be about a preventive attachment exercised by the Belgian tax authorities over the reimbursement of VAT ostensibly overpaid.
Indeed, and the critical issue that emerges from the judgment of the court is that such measures are acceptable as long as they are, for example, subjected to judicial scrutiny. And my submission is, well, precisely so here, because the remedy of judicial review is available if the commissioners are exercising the power in breach of public law principles.
Yes, I mean that case was concerned with the 6th VAT directive. I don't know if there are any material differences in the law that we're concerned with as it stood at the relevant time.
Not at the level of principle with which this appeal is concerned,
no.
Would be my submission, my Lord.
Okay, thank you.
So,
what's the position on interest? If
that's covered in that's also covered in this Belgian case, which may be worth.
It is, and again, it's covered by Mr. Justice Lakeman in UK Trade Court. The short point in my submission in relation to interest, however, is the present appeal is concerned with whether the commissioners have the ability and the power to do what they've done at all, not whether, if they're wrong about it, there will be consequential issues in relation to the charging of interest on the sums not repaid or credited to the taxpayer.
But the ECJ, I mean, I've only just seen this in the last couple of minutes, but they seem to be saying that if has been a wrongful delay in reimbursement of tax that was properly due, then in principle interest should be payable. The case is it's in the bundle at. All I can read are the digits 245. There'll be another one after that.
So perhaps at this stage,
just 453.
Perhaps I could give the court this reference of a summary of what was held by Mr. Justice Lightman on the basis of his consideration of Garage Molenheider. So the head note, or the rubric rather, of UK Trade Court at page 2243 of the joint bundle, just below letter B, the court will see point 2. Community law did not oblige member states to pay interest on repayments of input tax from the date of the making of the claim to repayment. Community law obliged member states to proceed with any investigation of claims to input tax expeditiously and proportionally, and to pay claims which were, or to the extent that they were admitted or established promptly, subject only to any due exercise of rights. It was possible that breaches of those duties might give rise to a claim under community law or national law for compensation for the period, in effect, interest. that all depends upon there being a wrong withholding. And as I understand, the essence of the argument for the taxpayer here is the only reason it's wrongful is there was no power to do this.
I thought ISOC had taken the matter on further, hadn't it? No? The case at 2396. Isn't there an obligation to pay interest?
Sorry, I didn't catch the reference that my lord gave.
So the ISOC case, which
Yes.
starts at 2397, and it was also referred to in your skeleton your submissions. I had perhaps wrongly taken up that there was an obligation to pay interest if, in fact, it transpired that money was owed and ought to have been repaid.
So it's paragraph 89 of our case, page 117 of the bundle. And within paragraph 89, it's subparagraph C with a reference to that case which has just been mentioned by Lord Stevens, ISOC. Insofar as the taxable person is deprived on a temporary basis of funds corresponding to the excess VAT, he is at an economic disadvantage which can be compensated for by payment of interest, thus ensuring compliance with the principle of fiscal neutrality. So, plainly, the Commissioners don't take issue with that idea, but our contention is that there hasn't been a wrongful withholding because the power was available and was properly exercised.
How does the trader get his interest? If he's content with the adjustments to the, can he appeal to the first-tier tribunal purely on interest?
So I think there may be a statutory provision dealing with this. If I'm reading this correctly, it may be section 78 1D of VATA. Section 78 is certainly concerned with errors, the provision for interest in cases of error. So section 1B, yes, where due to an error on the part of the Commissioners, a person has failed to claim credit under section 25 for an amount which he was entitled so to claim credit there, and which they are in consequence liable to pay to him. That's the statutory provision, but there is in any event the residual community law position that has just been looked at, that in principle, if there is a breach of the obligation.
That's referred to a failure to claim credits rather than a refusal of a claim for credit. So I'm not sure that section helps us.
Yes. Or maybe I think section 79 may also assist in this respect, but in any event, I don't dispute the proposition that in the case of a wrongful withholding, there appears to be a prima facie right to claim interest.
I do apologise for trying to clarify for myself. When you say wrongful withholding, if the amount is reduced from, say, 100,000 to 50,000, and so 50,000 is due, he's entitled to interest on the 50,000.
Indeed.
Yeah. Okay.
So it's to the extent that there has been a wrongful withholding. Lords, having reflected on where we have reached in the case, I wonder if it might be convenient to rise now. I rather suspect if we do, I can condense what I have left to say quite significantly with that opportunity.
It's, by all means, Mr. Thompson. We'll adjourn now and resume at 2 o'clock.